Hello, my name is Sarah Coderre, and I am an employment, human rights, and labor law lawyer at Bow River Law in Calgary, Alberta. Today I'm going to be answering the question of what is the difference between labor law and employment law? And the difference is pretty simple, actually. Labor law involves workplaces where the employees are unionized. They have joined a union, they have a union representation that negotiates and deals with the employer on their behalf with respect to issues in the workplace, whether that's their compensation, overtime scheduling, benefits packages, or really anything involving the employment relationship between a unionized employee and their management. Employment law relates to everyone else, anyone who is not unionized and is dealing with issues in the workplace of a legal nature. Those issues fall under the domain of employment law. So if you are a unionized employee, you would need somebody who has experience in labor law to assist you. And if you're a non-unionized employee, you will need somebody who has experience with employment law to assist you. A lot of the concepts and principles between employment law and labor law are similar, but how they affect and impact employees and a lot of the case law that's used to determine legal issues is somewhat different. One of the biggest differences, in fact, between labor law and employment law is that a unionized employee cannot sue their employer directly for damages, whether it's because they feel that they were terminated when they shouldn't have been, or there's some other issue that's gone on in the workplace that's impacting them. Um, Generally speaking, a unionized employee is required to seek redress and remedy for workplace issues through the union, and the union acts as their representative in any disputes against the employer. The one exception to this is that in some cases, collective bargaining agreements, which really is the main contract between the employee and the employer with respect to all of the unionized employees in a labor law context, sometimes that agreement specifically excludes human rights issues. And in which case, if you're a unionized employee and you've got a case of discrimination against your employer, then in that case, the union may not assist you because it's something that falls outside of the scope of the collective bargaining agreement and their role as an agent or a representative in your case. For a unionized employee, oftentimes, if they have issues at work, their issues aren't necessarily with the employer, although that can be the case, but sometimes they have issues with their union. Sometimes, an employee's been terminated, that employment relationship has ended, and they've asked the union to grieve the termination, to basically go to the employer and say, we don't think this person should have been terminated, and we're going to fight to try to get them back into the workplace or to get them some sort of damages or severance package. If the union doesn't agree with you that this termination, for example, should be grieved, now you've got a conflict with the union on top of a conflict with the employer. And the way to resolve that conflict with the union is by getting another lawyer involved to assist you in bringing a complaint against the union. And oftentimes these are called duty of fair representation complaints, and they're brought before the Alberta Labor Relations Board. And through that complaint process, a union may be forced to represent you in dealing with the employer. For an employee who's in a non-unionized environment, they have much more freedom in terms of claims they can make against the employer. They can sue their employer directly. They do not have to go through a union or another intermediary. In fact, while it wouldn't be advisable at all, they don't even need a lawyer if they don't want to have one. They can simply deal with the employer on their own. And so those are really the two big differences between labor law and employment law, the types of employees that are covered and the types of remedies and avenues that are available for employees in those different workplaces in dealing with issues. If you are not sure whether you are a unionized employee or not, certainly ask. You may be covered under a collective bargaining agreement and not be aware of it. You might be, for example, part of a faculty association at a university or a college and be sort of quasi-unionized in that sense. But your first stop should be somebody who specializes in labor law as well as employment law, because in some cases you may think you're unionized and you're not, and you might not realize that you are unionized and what that means, and you might in fact be. So getting proper legal counsel, regardless of what type of workplace you are working in, is absolutely vital if you've got an ongoing issue with your employer. Thank you.